Good morning. Happy Wednesday. It's a beautiful day. Very cold, but it's a beautiful day. It's about 36 degrees. Mrs. Mac, Little Mac's arrest seems to be causing further interest. So, with that said, I was asked about how to determine whether or not like a train station or a bus depot or whatever is a forum or not. And I think barring state law or state constitution, the federal courts looking at federal decisions will probably turn first to International Society for Krishna Consciousness v. Lee. This is from back before 9/11. So the airport terminal was open to everybody. You didn't have to have a ticket to get in there. It wasn't all sealed off and all that fun stuff. At that time, the Krishnas were asking for donations. They were soliciting, they were leafleting. And the airport, I forget which airport it was. It was some airport in New York State, had policies against those activities. And the court found that the airport was a non-public forum. And it actually split the decision. I don't know why. But there's the International Society for Krishna Consciousness v. Lee, and then there's Lee versus the International Society for Krishna Consciousness. The differences between the two is one said that because it was a non-public forum, soliciting, the ban against soliciting was permissible. It was viewpoint neutral, and it was reasonable. In the other decision, it said that the ban on leafleting, on just handing someone tracts, religious tracts or political tracts, was not reasonable. And I think it was probably just poorly argued by the state, by the government. They relied on the ban against leafleting because it would generate litter, and they didn't want litter. So that was a pretty weak reason to base it on. So there you go. My God, it's cold. My fingers are already numb. I know, 36 degrees. It's not even freezing. You pussy. Yeah. I live in California. I'm not supposed to be cold. Anyway. So, if you extend that same line of reasoning to other public transit facilities, then you're probably going to end up with, train stations, train depots, metro stations are going to be non-public forums as well. Now, these analyses are all fact-based. So, there may be some particular train stations that have been used as First Amendment platforms for a long time. And a court may find that a particular train station has become, through just years of use, decades of use, as a First Amendment platform. It may decide that particular train station is now a traditional public forum. And then congratulations. So it is very fact-based. But one of the facts that the court will look at is, do you have to have a ticket to get into that place? And the answer to that is going to be, I think, somewhat determinative on what kind of a forum it is, if it is a forum at all. It may be a limited public forum. If you buy a ticket to go into to see a speech like the White House Correspondents' Dinner or something, if you buy a ticket to get in, it's the purpose of that setting is to allow the speakers to communicate their ideas. It's a limited forum. But you get even a little weirder once you get on a bus or a plane. Just because it's owned by the government, if in fact it is owned by the government, doesn't mean you could do whatever you want as soon as you're in there lawfully. As soon as you buy that ticket, it doesn't mean you could do whatever you want, because the government is acting as a business in that capacity. If it is a government-owned and operated bus, and you buy a ticket to be on it, the government is acting like a private company. And so it can set terms and conditions on the purchase of that ticket. Now, there would be a First Amendment analysis of it, but it's a bus. You know, people are trapped in there with you on the bus. That would be part of the analysis. They can't get away from you. It would be distracting to the driver. There's a danger element associated in it. But there are lots of reasons why filming on a bus would be filming in a non-public forum. Now, does that mean that you can't film on a bus? Well, I'm going to say, generally speaking, you would be able to film on a bus, just in general. You start filming, nobody has any issues, or like if a fight breaks out on the bus and you start filming it, I don't think anybody's going to care. As long as, you know, you're not participating in the fight. But if it's at all disruptive, then I'm sure that they'd be more than allowed to do it. And it's going to be some sort of a reasonableness test, I would guess. If the court looks at it at all under a forum analysis, which I doubt, then it would be a reasonableness test for a non-public forum. Probably what they're going to be looking at it as, though, is a conduct restriction. If there is a policy on it, which would, since it is directly tied into a First Amendment issue, then it would bounce up to strict scrutiny. I think it would be a strict scrutiny issue. However, the nature of the location and all the other factors would probably warrant the bus to be able to restrict any videotaping that was disruptive of its operations, I would guess. Anyway, that's some rambling on it. I don't think that there's really a snowball's chance in hell that a court is going to find you have some sort of a right to film on a bus. It's not a traditional public forum. The government is restricting access to ticket holders, and it would be interesting, though. It would be interesting to see. Anyway, I guess that's really it. I've rambled for long enough. My hands are cold. Thanks for watching. Have a great day.